This video is called What is Fraud? And there are many categories of fraud offences: credit card fraud, insurance, tax, Centrelink, cyber fraud, corporate fraud, investment fraud. There are many blogs and articles on our website about fraud, about the different categories, about the defences, about how to defend a fraud case, and about our case results. The most commonly charged fraud offence is under Section 192 capital E of the Crimes Act here in New South Wales. It came into effect in 2010, replacing 6 other fraud charges. Before it came into effect, Parliament stated that this one provision clearly covers most fraud cases and ensures that only people that have been deceptive and dishonest will be prosecuted. Now, Section 192E states that any person who, by any deception, dishonestly A, obtains property belonging to another, or B, obtains any financial advantage or causes a financial disadvantage is guilty of an offence. The offence carries a maximum penalty of 10 years prison in the district court or 2 years if it remains in the local court. Now, to find you guilty of fraud under Section 192E, the prosecution must prove beyond reasonable doubts that you acted deceptively and dishonestly, and B, that your actions caused you to obtain another person's property, or to obtain a financial advantage, or to cause a financial disadvantage to another person. There are a number of terms in Section 192E which can be defined as follows. Deception is any deception by words or conduct, including deception as to your intentions or those of another person. For example, about what you intended to do with the money or the goods that were sought. Or it can mean causing any machine or device to make a response that you are not authorised to make. For example, unauthorised transfers of money. An omission can also be a deception. For example, it may be a deception if you fail to notify an authority of a change in circumstances when you would reasonably be required to do so. Now, the prosecution must prove that the deception was intentional or reckless. Otherwise, you must be found not guilty of the offence. For dishonesty, there's no list of what constitutes dishonesty, but Section 4 of the Act says that dishonesty is according to the standards of ordinary people. So perhaps knowingly stating something untrue when you are expected to tell the truth would constitute dishonesty. Now, the definition of obtains property is obtaining, enabling retention of, or inducing another to act resulting in ownership, possession or control of property, transferring to or staying with yourself or another person. It's quite a broad definition. The definition of property belonging to another is any property that another person owns or has a proprietary interest in. For example, a mortgaged home or business, the bank could be another person. For example, the bank is the mortgagee and they have an interest in that property and they can constitute another person. The definition of obtains financial advantage is temporarily or permanently obtaining, keeping or inducing another to cause a financial advantage for yourself or another person. For example, accessing funds that you intend to repay. So even if you intend to just borrow the funds and repay them, that can constitute the offence. Now, causing financial disadvantage means causing or inducing another to do something that causes a financial disadvantage to another. And for example, applying for a loan that is secured against a particular property when you know that the property does not exist or is worth less than you stated or is not yours, that can be enough. Now, fraud can sometimes be difficult to prove, so it can be hard for the prosecution to prove these definitions, these elements of the offences. A good criminal lawyer should be able to highlight problems in the case, highlight deficiencies and inconsistencies in the case, and should be able to write to the prosecution and push for the withdrawal of the fraud case. Fraud cases can also take significant time and resources to prosecute, and this can make our job a bit easier in terms of trying to get the charge dropped. A strong lawyer will be able to have those cases dropped by pointing out problems in the prosecution case and again pushing for withdrawal, or if that cannot be done due to the strength of the prosecution case, in having the number of charges and the amounts involved significantly reduced. Now, if your fraud matter is going to a trial, and these fraud trials can be quite lengthy, a team of senior defence lawyers who's experienced in these fraud matters can give you the best chance of success.